I think so, yes.
Yes? Oh, gone. Right, do you think we're all right to carry on? Right, okay, jolly good. Right, okay, thank you. I'm just looking through. So, do you think... No, perhaps not. Transport... Right, Transport Review Group 24. What's that? 411.11. Yes, in 4.11, after A to E, we have an option for alternatives. Probably all right, as long as presumably they comply with the minimum requirements set out in 4.1.1. Would that happen?
I think that's what it says. The following line has the relevant expertise to fulfill its duty in accordance with requirements of the Transport Group terms of reference.
So that refers to the alternatives. That would. Yeah, I suppose it would. Right. Okay. Yes.
Know that Mr. from at home can't hear us.
They can't hear
They
us.
can't hear, so that's one person. I don't know if anyone else is checking, but let me just double check.
Okay. Would be a bit of a shame if we had to stop now, I have to say.
It just says Lime Street. The
You are
lights.
watching it. It's all
It
right.
is.
Yeah.
Okay.
All right, let's carry on then. So we dealt with that. The final review of the travel plan coordinator. What was I worried about there? Right. Do we know what? Yeah, it says somebody's receiving instructions. And 5.1.3. Do we know what the duties of the travel plan coordinator? And you're going to be looking at the period of time, hopefully because that will all tie in, won't it? But until completion of the final annual review, so that will all have to tie in with the time period, won't it? Travel plan review. So I've got a question on 7.1.1c. So this is 7.1.1c. Is this another? Yeah, this is another thing about the time, whether the time period is appropriate, I suppose.
We will do a review of all the time
Yes,
periods,
yeah.
and I think we'll
Yeah,
drop them
sorry,
into a table and update it. I think it's probably the
Yeah.
best thing to do.
This is
Just
what
give you
I've
that
written.
to give you that certainty.
Yeah, I've just gone through this. Obviously, the same points probably. And I put the bus subsidy. In this case, is 10 years, isn't it? And that obviously we need to have some sort of justification for why it is 10 years rather than the 5 years for the other sites. Right. Yeah, and then the monitoring, that was the same point about the timing. Highway works. Well, I don't know why I put this, but I put here highway works doesn't include, I don't think, works the public right of ways, does it? Are they not included as highway works? 9.15.
Yes, that's correct. There's a separate
obligation in respect of the public rights of way works, which is in the subsequent paragraph. The public rights of way management scheme, as defined, has to set out.
Right, okay, just a minute. Let me just write that down.
Sets out the proposals in respect of the defined public rights of way works.
In 10.
Yes.
And then the definitions are on page 36.
Yeah, is that why I wondered?
Carry out the works.
Okay. Yep, okay, fine. Thank you very much. And then there's obviously an occupation, a requirement there to be considered, isn't there? It hasn't. I'll need to know why when you decide. I mean, I don't know. The contribution is going to be linked to occupation of so many dwellings, so that will be something that I will need to know why.
Yes, I'll pick up with Mr. Finch on that
Yeah.
too.
And that will be picked up. Good, all right, jolly good. And then the contributions similar to the northern site. So 10.1.1, yeah, we need justification of the contribution. 10.1.2, yeah, okay. If the, how do I put here? If there's a breach, so not to occupy or permit to suffer occupation of the development in breach of the obligations. So, I just wondered if you could explain what that means, please. Quite.
I think it's just a negative restriction to match the positive obligation to pay in 10.1.1.
So it's just if they don't pay the money, you can't occupy. Would that
Yes, I think it was envisaging that the payment might be staggered, in which case there could be a number of different triggers, and so rather than writing out not to occupy until such time as X has been paid, and then until such time as, or not to occupy X proportion of dwellings until X has been paid, it was trying to wrap that all up in one clause and say just don't occupy in breach of those collection of clauses, but we haven't yet established the triggers yet, so the drafting is incomplete, I would say.
Okay, thank you. Good. Oh yes, 10.14, you said that the management scheme should be submitted and approved in writing by the Borough Council in consultation with the County Council. Shouldn't it be the other way round? Surely it's the County Council that has to approve it, isn't it?
Yes, you're right.
Thank you. Pedestrian cycle routes. Yes, we established, didn't we, that these were just the on-site routes, didn't we?
Yes.
And you were happy that that was clear. Bus delivery and management strategy. That's 12. 12.13 and 12.14. What did I say about updating? No, that's right. I think that's okay. Tenor station contribution we've dealt with. So if, in terms of bus delivery, if the buses, I mean, it's possible, isn't it, that the buses or some of them could be delivered by the applicants, is that right? So if that happens, then what happens about the bus contribution?
It wouldn't be paid.
It wouldn't. But maybe, but that,
Proportion of it may not be paid. It could be.
right,
It
so,
depends on. It's proposed to be addressed in the strategy as to who will be delivering the bus services and whether and how much of the total potential contribution would be due.
okay. So it's addressed through the strategy. Okay.
And I'll raise our concern that I previously mentioned, because specifically on the south, that's the history of, you know, applicants doing their thing and then it affecting the commercial service.
Thank you. Okay. Any just final point? Any provision here for car clubs or electric bike hire?
I think that is covered in the sustainable transport strategy. From Mr. Wild. I will double check it, but it should be built in. I know we've looked at bike hire and other measures that should be through the travel plan. So yes, it should be in there. I need to
It might be that could be dealt with by condition, perhaps.
ask Mr. Wild now.
Well, car club especially, maybe.
Would that be a contribution, or that's built in, is it, somewhere to a contribution?
It wouldn't normally be a contribution. You would normally establish a car club.
Yeah, I mean, you presumably get one of the providers to.
Yeah, that's what we've done elsewhere.
Yeah.
I'm just
mean, that-
thinking about them, relating to the ones we already have in Sittingbourne.
That's what we normally do. We normally go and look where you know, for example, Enterprise may run a car club, and then you speak to the provider and they say, yes, we have a car club, actually it's really viable, we just start running one ourselves. Or they'll say, well, we need some subsidy to begin it, you know, to buy an extra vehicle, and can you provide a parking space with an EV charger or something on that nice route. So
Well,
that's what we've done elsewhere.
Yeah, I
but it's
mean, if
normally,
that- Yeah, I would like a provision in the legal agreement because if,
I think a standalone provision's probably a good idea. So yes.
yeah, because if certainly if there's any funding necessary, then you
Yeah.
couldn't really do it in a condition.
Yeah, and normally it doesn't state the funding amount. It just normally sets out the provision of a requirement for a club, because you can then go to the different
Yeah.
commercial operators.
Well, anyway, I think it should be looked at.
I think charging points is quite.
Charging points. I think there are conditions, aren't there?
Planning
about
condition,
houses
yes.
having charging points.
Yes.
Well,
I will check with Mr. Wild if it's built in already to an existing clause. I will check with Mr. Wild, and if it's built in fully to an existing clause, we will check it as well.
what, the car club?
Yeah.
I
I don't
mean-
think it is specifically mentioned. I'm sure you would have picked up on it.
Yeah. I mean, basically, they obviously usually how it works, isn't it? That there would be spaces provided in each of the. Yeah.
May I ask, does that also apply to the northern site?
I think
Yeah.
it should do, yes, yeah.
Thank you.
Right, you'll be very pleased as far as I'm concerned.
No.
That's it. Yes,
Sorry,
that's all right.
always the monger of doom.
You've got half an hour.
Oh, I won't spin it out because I know we're all desperate to go and it's hot.
Carry on.
Right, okay. Just looking at the parties on the agreement, and I think
Which agreement?
the section one
No,
is
wait, I'm sorry,
south.
The south one.
Yep. And I think under glasses on ID 100.25.1.
Hang on. ID 100.25.1.
Yeah.
Let me just get that up. Oh yeah. Okie dokes.
I think we've got on the front here, what was the name of the party? Let's have a look. Sorry, I'll just scoot back up the top. There are parcels, title 32 and 33 has got the Southern Relief Road running through it. And they, I believe, are not party to the Section 106. And they are Kent Holding BV, which is a similar name to the other party that are on here. And they, so title 32 in that map has a bit of the, if you look on the
Plan.
on the plan down here,
Let me just get my plan then. Hold on.
one, I think. Let me just check. It's an ID. It's an ID doc.
25.1. I've got the titles, but not the
Hun-
plan, so it must be.
32 and 33.
That's it.
Right, it's that one.
Yeah.
So
Oh, I see. Right. Okay. I see. Yes, a tiny bit goes over. Yes, you're right.
So that's in 32 and 33. And then what was the one on 21 as well? Title 21.
Yeah.
Which I think they AG Kent Holdings. Anyway, you'll need to look at those.
So sorry. What point are you making here?
Well, if you look on the map there, on Title 21, you've got a bit of arm of roundabout on there.
you're basically saying they should be party to the agreement.
Yeah,
They're not party to the
They
agreement.
should be party to the
Yeah.
agreement.
Are they
They're
not?
not
I
currently.
think
No,
but I think, well, the company name is, but the title reference number, I don't think is.
there are two different entities with
With
And-
similar names.
Yes, that's correct. They're both entities that have land holdings as part of the science park. So AG Kent Holding at number 21 is a party to the 106 agreement, and a sizable portion of their land is actually required for the purposes of the development. They are therefore named as a party. By contrast, 32 and 33, owned by the slightly different entity, Kent Holding BV, we include a paragraph or so of text in the schedule explaining the reasons for which they should not need to be bound by the agreement. That's essentially because the only incursion into their land is in the very southwest corner. Sorry, is in a very small portion of the science park, which is for the Southern Relief Road and a new access. They don't need to be a party because they couldn't. The land that they own, they couldn't meaningfully implement the development and be able, with the permission, and be able to take free of the 106 agreements, which is what the council should be concerned with when considering which titles to bind in.
Sorry. So if they're part of, if they own land that is within the development site that's needed for the Southern Relief Road, surely they need to be included in the...
No, not necessarily, because we've got a suite of obligations in here which requires the relief road to be delivered prior to occupation. We can't occupy until the road is delivered. We have to secure the land in order to be able to do that. There are various triggers in the 106 agreement preventing the transport infrastructure from being preventing occupation until the transport infrastructure is brought forward. They only have a very small portion of the site. So, say for instance, there was a large portion of land on which a number of dwellings were going to be delivered. It would be inappropriate for that party to be that land not to be bound, because in theory the developer could build a significant number of homes and, for instance, not pay any of the obligations. It wouldn't be bound by the agreement. In this case, there's only a tiny little bit of an access road going through. if they were to go on site and deliver the access road on their land, they wouldn't derive a benefit from the development and not pay the contributions, for instance. It's a completely different situation. It's quite common in situations like this not to bind in every single party to every single landowner. We have the comfort on the one hand that there are triggers requiring the transport infrastructure to be delivered prior to occupation, and the council has the comfort on the other hand that this party couldn't implement the development. They couldn't go and build loads of homes and take free of the 106 obligations, which is what the council is considering when they're assessing which parties should sign up. That's the position that we have taken.
Can I just say that, I mean, the number of lawyers is dropping slowly, but there's the Robert Hitchens case, which made clear that you don't need everybody to be signatory to the Section 106. You don't need all the land, in fact, either. Of course, there's fundamental questions about how much you do need, but this is a very small area.
Okay, fair enough.
I know that this is something that my solicitor is vexed by and is looking into, so from the council's perspective, this is still work in progress.
So, Ma'am, we sent you in the parish councils in our evidence about a title split in the top 12 inches in the bottom. This land where it comes round here is very close to the issues that we described with the Shell land, and I think this could be storing up a problem.
Sorry. Sorry, you... Can you just
We
repeat
pointed out that there is, when the land was sold by Shell, they split the ownership into...
Right, start again. Sorry.
When the land was sold by Shell, and we've appended it in our original submission to...
What, the statement of case?
Yeah, I mean, we reference it in our evidence all the way through. But there was some concern around how the land had been historically used, and there is a transfer that shows that there is a hole in the title there, which is where it, I think, appeared to coincide with what the locals had said around what had happened on that site historically and how that land was used, which may cause an issue, and I see why the road curves there, because it skirts around that land, and so you're forced to bring the road into this land holding here. I think this is about site assembly, and I do think these are important pieces of land here. The science park will be one of the big beneficiaries, because this is the main landowning of the science park.
But we can't occupy any dwellings until we've brought this forward, so the problem is ours.
No, but the obligations, obviously, they transfer, and you're going to have one of the main beneficiaries here not being an obligation to all these planning requirements.
Okay. Sorry?
Sorry, ma'am. 32 and 33, they are within the red line.
Yes.
They're de minimis portions of land in the context of this on which there's a very limited amount of development, which it's very usual to exclude in circumstances such as this. There's no need for them to be a party to the 106 agreement. They could not implement the development and take free of the obligations, plus the delivery of the transport infrastructure on their land is secured by the restrictions that we have in place in the 106 agreement. So for those two reasons, they don't need to be a party.
Do you have an agreement with them?
Yes, our client is able to access the land to deliver the road anyway.
But we haven't seen any demonstration of that.
But there's no need to be concerned because of the restrictions in the 106 agreement.
Mr. Digan, you said that your solicitor was still looking at the issue.
Yes, ma'am. So I'm not an expert in titles. I have to be guided by the solicitor in terms of what she requires and so forth.
We haven't got her here today, have we?
Seems to have a family emergency.
Oh, okay. So anyway, she's looking at, or he's looking at, what, just these 2 small bits of land?
No, as I understand it, she's raised lots of issues
About the titles?
about title. Yeah.
It's probably worth adding that we've agreed the title position with Kent County Council.
Sorry?
We have agreed the title position of the parties to the agreement with Kent County Council.
I don't know whether that's...
I don't think it's a matter of an impasse. It's just something that is still being worked through, and it may well be that if the KCC and the applicant and our solicitor can then talk it through, it might resolve the issue. It's just work in progress. It's not as if we've reached a stalemate or anything.
I mean, presumably...
We undertook this exercise with Kent County Council before Swale appointed their solicitor to try to avoid a duplication of works. We did an extensive piece of work with Bevan Britton and KCC
Yeah. And
to avoid exactly this
Our
problem.
client's property solicitor has been in extensive negotiations with Swales. Yeah, our client's property solicitor has been in extensive conversations with Swales solicitor in relation to this as well. We've provided a great deal of information, and this has now been with Swale Borough Council for a very long time, and I would hope we could have resolved it by now.
Right. Okay. Jolly good. I think that's enough, isn't it? Yes? Well, dear. No, it's 4:45, and I think we should be pleased that we've actually completed what we were set out to do, which is great. So well done, everybody. So we've got a bit longer, but could you please clear your things as quickly as possible, hand in your badges, or at least post your badges back, and have a very nice summer, and see you in October. So we will adjourn till the 2nd of October, 9:30. Yeah. Oh, the site visit, okay. Yeah.
I've got one party who said yes on Wednesday.
Wednesday.
And I'm just waiting